Hello all, as 2025 marks 50th year of imposition of national emergency in 1975, we are going to discuss one very important judgment given by Allahabad High Court, which along with few other factors led to imposition of emergency in 1975. That very famous judgment or case is Raj Narayan case of 1971. This case was filed in 1971, but the judgment came in June 1975, and hence we are going to discuss about this particular judgment. So what happened at the time or under this case is that both Miss Indira Gandhi and Mr. Raj Narayan, they had contested the general elections of 1971 from the seat Rai Bareli, which used to be the constituency of Miss Indira Gandhi, right, which is in UP, right. So both of them, they had contested from Rai Bareli. Indira Gandhi, she was contesting from Congress party, and Mr. Raj Narayan, he was contesting from Sanyukta Socialist Party. In this election, Indira Gandhi got more number of votes and hence declared as winner, or she became the member of parliament in Lok Sabha from Rai Bareli seat. Eventually, she became the Prime Minister of India as well. But Mr. Raj Narayan, he filed a case against the victory of Indira Gandhi in the Allahabad High Court, saying that Indira Gandhi during the election time, she has committed some malpractices or some corrupt practices under Representation of People's Act 1951, RPA 1951, and hence because she has done some corrupt practices, her victory, her election should be declared as void by the court. Now court, it has done intense hearing. The case was first been transferred from one judge to another, then to third judge, and ultimately after intense hearing, or for the first time, a sitting prime minister was called by court and cross-examined for 2 consecutive days. After these 4 years, from 1971 to 75, in June 1975, court passed a verdict. In this verdict, Allahabad High Court, it had said that out of many allegations levelled by Mr. Raj Narayan against Miss Indira Gandhi, at least 2 they found as to be correct, and they had said that yes, some malpractices have been committed during the election by Miss Indira Gandhi, and hence her victory or her becoming the member of parliament from this constituency becomes void. She will no more be the MP from Rai Bareli. If she doesn't remain the MP, we all know, to become or to remain Prime Minister, you have to become a MP first. Even if you are not an MP, you have to become MP within 6 months, right? So you can't become Prime Minister without being an MP. So that's what the implication of this verdict are going to be huge. Reason being, if you are not a MP, you can't remain a Prime Minister as well. So court had said that yes, 2 of the malpractices which have been under RPA 1951, Representation of People's Act 1951, have been committed here. One is that Miss Indira Gandhi, because she was Prime Minister, she had used the government machinery, the machinery of the state of UP, to set up stage, loudspeaker for herself during her own party's rally, right? It was not a government work, it was a rally of Congress party. For that rally, it was the state machinery of UP state which was used by Miss Indira Gandhi to set up stage and loudspeakers. And secondly, that she used one of the gazetted officer as an election agent. So an election agent of any candidate cannot be a government gazetted officer, but Indira Gandhi's election agent was a gazetted officer, right? Although he had resigned, but before his resignation was approved by the government, during that time also he had taken some of the responsibility of election agent of Miss Indira Gandhi. And on these 2 grounds, the important things to remember is that High Court of Allahabad in 1975, to be precise on 12th of June 1975, passed a verdict that Indira Gandhi is no more a MP of Rai Bareli, right? This verdict, it has changed the political or the political history of India. We'll be seeing how. So as soon as this verdict came on 12th of June 1975, the legal representatives of Miss Indira Gandhi, they again approached to High Court. They immediately approached to High Court saying it will create a political vacuum in the country. If she is not a MP, she will not remain as Prime Minister, right? Who will govern the country? And hence, what High Court of Allahabad did was, High Court of Allahabad, it itself gave 20 days, 20 days for implementation of this particular verdict. They had said for next 20 days, this verdict will not be implemented. Reason being, in next 20 days, what Congress party can do is, Congress party can elect a new leader in place of Indira Gandhi. That was the thinking why High Court had given 20 days of extension. But in these 20 days, what Congress party did was, Congress party first of all, CWC, the Congress Working Committee, right, it passed a resolution that Indira Gandhi only will remain the Prime Minister of the country or will remain the leader of the Congress party. And secondly, they had appealed the judgment of the Allahabad High Court into Supreme Court. Now, Supreme Court, as we all know, during summer, during the month of May and June, Supreme Court also goes on summer vacation, right? And during those days, only 1 or 2 judges or the vacation bench of Supreme Court works, right? And hence, this particular case, it was appealed in Supreme Court to a vacation bench, to a single judge bench of Supreme Court. This single judge bench, it did not pass the final verdict. It had given an interim verdict on 24th of June. Right, on 24 June 1971, after 12 days of Allahabad High Court's verdict, the single judge bench, it had said, we are staying the judgment of Allahabad High Court, but conditionally. So conditional stay was given by Supreme Court. They had said that final verdict will be given by the full judge or by 5 judge bench of the Supreme Court, not by a single judge bench. But till that time, we are staying the judgment given by the Allahabad High Court conditionally. What were the conditions? Conditions were that Indira Gandhi will remain the Prime Minister as well as MP. But even if she is MP, she will not be having the right to vote in Parliament. Secondly, she will not be getting the salary. She will not be drawing the salary as MP from the Parliament. So some small conditions were put. But apart from those conditions, the Supreme Court had said, till the time a final verdict is given by 5 judge bench of Supreme Court, Indira Gandhi is going to remain as Member of Parliament as well as Prime Minister of India. As soon as Congress party or Indira Gandhi got this verdict in favor of itself, what the next thing Indira Gandhi government did was, Indira Gandhi government recommended to President of India on June 25th that it is time to impose national emergency under Article 352. The reason given by government is that internal disturbance or there are people who are instigating the citizens of this country to take up arm and throw the government forcefully. So she had used the word internal disturbance given under Article 352 to or as a reason to impose a national emergency in India on 25th June of 1975. So you see, on 12th June, Allahabad High Court's verdict came. On 24th June, a single judge bench of Supreme Court gave a verdict, and on 25th June, the government imposed or the president imposed national emergency. Right, and hence it is the national emergency, it is very closely linked to the verdict given by the Allahabad High Court in June 1975. What happened during the time of emergency? All the constitutional guarantees which were given or which government had to implement, they all were subverted. For example, opposition parties leaders, they were jailed without any trial. So their cases did not reach to court, without it only they were jailed, meaning most of the fundamental rights of the citizens were taken away. Elections which were due in 1976, after 1971, the next elections were due in 1976, they were also postponed, they were also not conducted. Then other things like, for example, the parliament its authority was subverted, and executive, it assumed most of the powers, right. So many constitutional guarantees which have been given to us by constitution, they all were subverted during the time of emergency. Emergency was there in force for 21 months, and it is called as dark period of India's democracy. So all such things have happened during the time of emergency, and again this emergency, it is very closely linked to this particular judgment of Allahabad High Court. Now during the time of emergency only, in August 1975, what Parliament also did was, Parliament passed 39th Constitutional Amendment Act. What was written in this act is, Parliament had written that from now onwards, election of President as well as Prime Minister will be outside the purview of judicial review, meaning judiciary cannot do judicial review of elections of President and Prime Minister. To other MPs and MLAs and other constitutional offices, judiciary can review their election process, or I mean any allegations if they are made during that there are some malpractices done during the time of election, that can be reviewed by judiciary, but not of President or Prime Minister. Now this Amendment Act of 1975, 39th Amendment Act of 1975, it was later on in the same year, November 1975, it was struck down by Supreme Court, right. The 5-judge bench of Supreme Court, it said that free and fair elections for the post, for any constitutional post, be it President or Prime Minister or MP or MLA, all of this is a basic structure of Indian Constitution, and hence it has to be reviewed by the judiciary, and this Amendment Act, it was declared as null and void. But the same bench of Supreme Court in November 1975 also passed the verdict that the judgment given by Allahabad High Court on 12th of June in Raj Narayan case, they overturned that judgment. That said that the election of Miss Indira Gandhi as MP of Raebareli, it is fair, right. So the judgment given by Raj Narayan case, or by Allahabad High Court under Raj Narayan case, which led to imposition of emergency, that was done away by Supreme Court in November 1975. You see, so this emergency which was imposed, it has changed the political history of India. It has also changed the relationship between judiciary and executive. So from this time onwards, from early 1970s only, we see that interference of executive, or basically government, into judiciary started increasing. The first such major instance which we had seen is that in 1973, one of the judge of Supreme Court, Justice A.N. Ray, even though he was not the senior most in the hierarchy of Supreme Court, he was appointed as the Chief Justice of India, overlooking the seniority of other judges. Reason being, he was more favorable to the government. Some of his judgments were tilted towards government. For example, when in 1969 nationalization of banks was done by Indira Gandhi government, Justice A.N. Ray passed a judgment in favor of the government. Similarly, in 1973, when Keshwanand Bharti case or judgment came, in that judgment a 13-judge bench of Supreme Court passed a verdict with 7:6 majority. 7 judges were of the view that the amending power of the Parliament is limited. On the other hand, 6 judges were of the view that Parliament has unlimited power to amend the Constitution. Justice A.N. Ray belonged to this 6-judge group, right. He wrote a judgment in favor of the amending power of Parliament, and hence Justice A.N. Ray, he was, even though he was not the senior most judge of the Supreme Court, he was elevated to Chief Justice of India in 1973, overlooking the seniority of some other judges. Similar thing the government did in 1977 with Justice M.H. Baig being superseded, being elevated as Chief Justice of India, overlooking the seniority of Justice H.R. Khanna, right. Justice H.R. Khanna, he also during a particular case which is very famously called as habeas corpus case, he gave a verdict against the government. So it was seen as the interference of executive into the affairs of judiciary, because the tussle between judiciary and executive started, and one judgment of Rajnaran case that also had a role to play into this. And hence, if you all know, because interference of executive into the functioning of judiciary started, what Supreme Court has done is, through first judge, second judge and third judge case of 1980s and 1990s, Supreme Court had come up with, or they have come up with, collegium system. They have taken almost all the powers which executive had in the appointment of judges, and they had taken it to themselves. So that thing we have discussed in some other video as well, how the collegium system evolved, right? But basically during that time, or 1970s was the time when there was lot of interference of executive into the functioning of judiciary, or independence of judiciary came under threat. So, and hence you see this judgment, Rajnaran case verdict by Allahabad High Court, it has so much wider implications of political history of India, of independent India. Secondly, how the relations between judiciary and executive, they changed. So I hope this video was useful to you. You have understood in what background emergency was imposed in India. Thank you so much for watching this video. If you liked this video, please do subscribe to our channel. Thank you.